everyone, and welcome to this edition of Judgment Day. I'm Lorne Honickman. The pandemic and the courts. In previous segments of Judgment Day, I've talked about the many court challenges that have taken place with respect to the emergency health regulations that the provinces have brought in, the federal government has brought in. Courts have been very busy in that context, dealing with a lot of charter challenges, examining these new laws and regulations. But I can tell you that the courts have been also very busy analyzing what we would call long-standing principles in law in the context of the pandemic. For example, family law, a very important concept, deals with the best interest of the child. And of course, you can well imagine within schooling or schooling online, judges have had to apply those principles given that context. Well, perhaps one of the more, if I can use the word, volatile areas of law that has really been affected by the pandemic is employment law. Long-standing principles in employment law, such as mitigation, what's an appropriate notice period, constructive dismissal if you're temporarily laid off, all of these things that were normally adjudicated and well understood in the law now have changed a bit as we see judges giving a lot of different and distinguishing reasons, again, in the context of the pandemic. And of course, now that we're coming out of it, so many people, employers, employees, wanting to know what their rights are. So let's talk about it. I want to bring in lawyer Paul Schwartzman, a specialist in employment law, and who over this crazy time period has joined my law firm, Brody Thorning LLP, as a partner in the employment law department there. And welcome, Paul, to Judgment Day.
Thanks for having me, Lauren.
It's good to see you. I know we've talked several times, but okay. So Paul, let's talk first of all, before we go to some of the cases, because I know there's been a lot of interesting cases right across the country and how they're dealing with a lot of these issues. But right now, as we stand today, you know, where quote looks like getting out of the pandemic, people are going back to work. What are some of the important things? Let's start from an employer point of view. What are some of the things an employer is going to have to think about now?
Yeah, so the biggest questions we're getting obviously is can we mandate people to return back to work, specifically for those employers who've shut people down, who had remote working arrangements? Are we going to do hybrid? Are we going to say continue remote? Are we going to say everyone back? The most popular question also, can we ask about vaccination status? We have presidents and CEOs saying, Paul, I don't care what the law says. I want my staff to be vaccinated. What can I do to ensure this? Can I incentivize people to get vaccinated? Can I promote vaccination? These are all novel issues that are coming up. So everyone's kind of head is at this return to work, you know, as we're going to stage 3 in Ontario now, nicely starting, next week.
Right.
Employers are thinking the same thing. Okay, when can I start getting people back? But those are probably the most critical issues right now. Is most of them are hoping to kind of get out of this remote phase and see people back in the office.
So yeah, and let's talk about for a moment before we move to some of the more volatile issues that we've seen in the courts, the vaccination issue. So what's the advice here? Like employees, somebody says right now, are they going to force me to get my second vaccine? Are they going to force me to get my first? Those who aren't vaccinated, are we going to see the courts filling up with some of those applications?
You may see them from a human rights context in the event that the employer tries to say we want people mandated. There's also there could be a privacy complaint, even just asking, we want this information. Someone saying, I'm not giving it to you. I think employers would have more leeway on the commencement of a new employment relationships, making things conditions of employment could again be human rights grounds, but they're gonna have a lot more leeway than, telling that to an existing employee. Because really, the existing employee is gonna come and say, if they say no, and the employer says, well, now you've breached my policy, that's not gonna be cause for termination. So are they gonna call your bluff, and then the employer's kind of put in this situation? Are you prepared to pay out severance over this, right, and terminate?
And then think about people working in that environment and saying, well, wait a minute, you're not you're not mandating that my fellow coworkers have to be vaccinated. Now my right side, this is now, I don't want to say, this would be like me sitting beside somebody who's a smoker,
Yeah.
and saying like, you can smoke, but don't do it around me. You're not vaccinated. You can see now the vaccinated employees having those concerns and putting the pressure on an employer.
And that's exactly it, and it's happening, and so there people are asking questions, and an employee doesn't have the right to dictate, who they sit beside, or that, if I'm sitting beside you, that I want to know that, Lorne, you've got your second vaccine, or I'm not coming to the office. You don't have those rights. But I think what employers are doing is they're looking at it more, instead of having, your traditional 9 to 5, here's your office, come in Monday to Friday. They're looking at hybrid schedules, they're looking at remote arrangements, they're looking at hoteling concept. So maybe we don't have our office next to each other every day. You can meet more people. They're now hearing feedback from employees who are saying, oh, listen, I'm happy to come to the office. I just don't really like sitting next to this person. It's been nice, not seeing that person for a year, 2 years. So they're getting this honest feedback, and employers are starting to listen and think about, okay, like, how can we make it fun to get people to come back to work?
All right, let's talk about some of the cases that have made it into court. And I talked about some of these longstanding principles that we deal with in the context of employment law. So why don't we start with notice periods first? So just so everybody understands, again, if somebody has been dismissed, and now the court has to determine if it's a wrongful dismissal, what is the appropriate notice period. That principle, like many, Paul has been there in the law for a long time. Let's first talk about how has the pandemic changed that? How have judges been looking at that now?
Yeah, no, it's a great question. So, I mean, because obviously the economy took such a hardship through COVID, the whole purpose of severance of the notice period is you're estimating objectively, how long ought to it take someone to find a new job from when they were terminated. Well, for the employees coming out saying, if I'm in retail, or if I'm in a server in a restaurant at the beginning of COVID and I'm let go, I'm saying there's no jobs that I'm qualified for. So what does that do to the notice period? That was the argument. And some employees would say, and their counsel were trying to say, well, then there should be called a COVID bump from the usual principles of the Bardal case, where we look at, age, length of service, and
Right.
position being the standardized factors. They would say, well, you need to have a bump as well. Employers would say, well, no, now you're penalizing us, and we're already, our business is going through such tough times, and now you're going to make us pay, additional severance on top of it. So courts were grappling with this, and what it's come down to, I think, courts have made a smart decision to say, look, we're going to look at the industry, because not every industry was decimated. Some industries actually did well. New industries emerged. People have different types of credentials, and they're not going to just assume going into court that it's going to be more difficult for an employee because of COVID. The courts have basically said, we could consider bumping the notice period, but you're gonna have to show us evidence. Show us that the industry, what show us some evidence. We're not just gonna make an assumption. We're not gonna do the work for you. And so we have yet to see. We've seen courts consider these principles. We have yet to see them, or anyone for that matter, go to court and actually provide evidence on what's going on in a specific industry.
And that's interesting, because there's a case here in Ontario called Mazzarato, and Justice Dow looked at exactly what you're talking about. He was asked to take into consideration the economic downturn caused by the pandemic, and that therefore that would be a basis to say, yeah, there's difficulty. But he said, as you just said, I need some evidence of that. So judges, I take it, aren't just taking it as a fact that pandemic, hard to get a job.
Exactly. And I think judges understand that they don't want to go off the scale of the normal Bardal factors either. I mean, you're putting in, some of these employers have been in such a difficult time, some of them being obviously forced to let people go. So to again, hammer them again with, how high are you going to go to the notice period? They're still trying to stay within the regular principles. Having said that, I mean, I think for someone who's in their 50s or 60s of an industry that's been decimated, long service, you may see someone get bumped up from an 18 to a 22, or from a 20 to a 24 potential notice period, depending on the case.
Right. Now, is this, because I said before, we're getting a lot of different types of judgments in this area. Has this been consistent across the country? This type of analysis that you may get your notice period raised, but you have to bring evidence? Are all courts been determining this the same way?
Pretty much. I mean, I guess we're kind of fortunate. I know in Ontario, we seem to always be the first ones dealing with this. So a lot of them just cite the same Ontario case law to kind of go back and say, oh, you know what, that's pretty straightforward. So they pretty much, you haven't seen, nothing's been out there. Most of them have cited it. Most judges have considered arguments. I think in some cases, they haven't adopted a argument. You could, if you looked at some cases out of BC, you may say, you know what, the judge gave at the upper end of the range. So you may think, maybe COVID influenced that decision. But the judge hasn't come out and explicitly stated that. They've kind of held their cards close to their chest, so to speak. So I think there's a bit of a, no judge really wants to come out there and have that, decision that's saying, well, you're so off the charts because of COVID.
Right. Well, okay. So let's look at where I know there's been some inconsistent judgments because again, it was so new, and that's dealing with SERB payments. We all remember that from last year when people were losing their jobs. The government came out with these SERB payments, and in the context now. To me, the interesting question has always been, well, how are the courts going to look at SERB? How are the courts going to say, well, if you got those SERB payments, should that be deducted? But let's say you get fired. So you got fired because of the pandemic, you allege wrongful dismissal, but you got your SERB payments. Is that going to be considered what's called in law mitigation? In other words, should that be deducted from the damages? And you sent me all these cases, and it seems like we're getting lots of different judges giving different judgments on that.
Yeah, and I think the first thought when SERB initially started and we had these issues was, should it be treated the same way as employment insurance? Because employment insurance, as you know, is not considered mitigation income. There's no deduction,
Right.
and the reason being is that someone who receives EI, it may have to pay a portion back if they're also getting severance through a settlement or through judgment. The difference in SERB, and I think at least this is where there is some consistency, is at least it's different than EI because there's no you don't have to pay it back. So I think most judges, I think where you can kind of reconcile some of the cases is judges will say, well, yeah, it is for loss of income, so it should be mitigation income, but we're also going to consider, at least in Ontario, how much SERB did you actually get? And if it's a nominal amount, and this kind of also plays into this break case by the Court of Appeal, we're not going to necessarily call it mitigation income. So, in that case, someone had taken a part-time job at Sobeys and just for something to do while they were waiting. Judge said, you made like $5,000. Before that you had like $80,000 salary. We're not going to call that mitigation income. So I think that, they still say on a case-by-case basis. I think generally it should be frankly mitigation income. But look, if it's $2,000 or $3,000, if it's something small, a judge is going to say, nah, forget it. We're not going to factor that into the formula.
Right. But, and again, these are all courts at first instance, or like here in Ontario, the Superior Court. I take it there hasn't been enough time for appeal courts to look at these issues yet.
That's right. And I think part of the reasoning too is in the cases where it has been decided, the amounts haven't been huge. It hasn't been worth it for either side to really appeal and spend the legal costs. I think it would be a point that's, if there's other grounds of appeal, I think it would get up there and someone I'm sure would raise it just to get a deduction for their client. But on that issue alone, I doubt you're going to see it go ahead because SERB, there's not going to be an amount that's going to make sense given the legal costs of appealing. It's just not going to make practical sense.
Right. All right. Well, let's go to one area that I think, and I could be wrong, Paul, but has affected maybe more people than any other area as it relates to employment law through the context of the pandemic, and that is a temporary layoff. So many companies would say, well, we got to lay off on a temporary basis because for obvious reasons. And a lot of people came forward. I know a lot of litigation began and said, well, wait a minute, you're laying me off temporarily. That's a form of what's called in law constructive dismissal. And for all intents and purposes, you've now just laid me off. And I know that there is regulations, for example, here in Ontario that said a temporary layoff in the COVID period would not constitute constructive dismissal. However, the courts have given us some different views on that, haven't they?
Absolutely. And lots of confusion and lots of commentary on both sides and certainly some fun debates are being had about this issue. But yeah, I mean, you're absolutely right. I mean, I think it was pretty settled that before, obviously, if it's not part of your contract, or if you weren't temporarily laid off before, such that, it became a term of your employment, temporary layoffs, a constructive dismissal, comma, we can all agree on that. The issue was this new ESA regulation in Ontario, which deemed a temporary layoff to be someone being placed on the infectious disease emergency leave. What does that mean? And what does this regulation mean is what the courts really have been grappling with. And you have people, frankly, more, I would say, employee side firms saying this is the same thing as a layoff, it's a constructive dismissal. And you have more, I would say, employer side firms saying, no, this regulation is recognizing these exceptional circumstances, and it'd be ridiculous to have employers have to pay out severance in these times. And we saw two judges with diametrically opposed view, and one said the other decision was, quote, wrong in law. So very interesting, and obviously has to be settled by an appellate court to find out where we go here.
Well, how is it, and maybe you can explain this, because you got a regulation, and it's the government putting in this regulation that says it's not going to be deemed constructive dismissal, but the common law has looked at it differently through the years, and that's what I was talking about earlier. Is these principles and how they've been affected by the pandemic. How is it that you can just, in Fogelman, Justice Vela basically says that the regulation cannot supersede the common law civil remedies. I mean, but it's a regulation. It wasn't struck down under the charter. So I was having a hard time understanding how is it that the common law in that case cannot, that the ESA could just not supersede it.
Yeah, and I think one of the questions that's really out there is how does the common law treat an infectious disease emergency leave? Because we have the common law on, right, being placed on a layoffs, a constructive dismissal, but I think that's what the appellate court really needs to do. Is when you have this type of a pandemic and you have employers who have to take some of these actions, and considering this regulation, I don't think it's necessarily as simple saying, well, it doesn't or it does supersede it.
Right.
I think there's an in between to allow some leeway. The other thing to note on that regulation, and again, of course, they didn't define it, but they said it's, it applies if you're laid off for reasons related to COVID-19. Well, how far do you have to go, right? If I'm being totally shut down, you're an employee, okay, fine, I have to lay you off. Maybe I don't like you or was thinking of terminating you in any event. So maybe I say, oh, well, now's a good opportunity, right, to put you out there. So I think there's a lot to grapple with, but I think, yeah, in terms of the principles of the intersection of ESA and common law, that's a debate in and of itself. I mean, it's not, the ESA, it doesn't preclude a civil action, right? I think we agree on that, right? Section 8. Okay, but does that necessarily mean it's a constructive dismissal? I think that still has to, that still has to be determined.
Okay, so let's talk then now about, because I think this leads to a very good, an important question. You've been in this is the hypothetical, you're an employee, you were in a company, you got laid off temporarily, hopefully, or whatever, and now your employer's reevaluating the post-pandemic now, and says, look, I know we had 50 people working here pre-pandemic, we can only afford 25, we're really sorry. Though that person that doesn't get his or her job back, do they have a wrongful dismissal case, a constructive dismissal case there?
Well, I think wrongful would be the easiest way to go for that person. If the employer is, in your example, saying to them, like, you're not one of my 25, or like, you're not going to,
because I can't, because
yeah,
look at what happened.
Well, then absolutely, then you're terminating me, right? It's, now the only thing is you may say, it depends, or are you saying to me, Paul, at this time I can't, but I'm hoping in the fall to change, so I'm going to be placing you on this infectious disease emergency. Then yeah, I would probably tell you, that person should go and, and bring the action. But I guess, with some caution from their lawyer, hopefully, that we don't know what the Court of Appeal is going to do. Another thing, if the person has the ability, and most of course don't, but to wait it out, is if the person didn't take action, and let's say they were never called back to work, they're gonna have to wait some time. The regulation doesn't expire till September 25th. But if you wait basically, 13 weeks, so again, you're going basically to the end of 2021, eventually they would be terminated, but they would still accrue service throughout this time. So maybe if I have some other another job lined up, or if I know something I can do in the interim, maybe I just wait it out. If I want to be more aggressive, sure, I'm going constructive with a good lawyer. I'm going to push it. But in the background, I'm sure that lawyer is going to be saying to them, well, we can do this, but we're still waiting to see the appeals of these other cases and where it lands up.
So let me go back to what we were talking about earlier. So many people working from home, like yours truly.
Yeah, I haven't got to meet you in person yet. I was going to say.
That's right. You joined the firm,
Yeah.
and I haven't met you before.
Yeah.
You know, and I've got, like so many other people, I've now got to start bringing it back in and start thinking about that. But there will be people, Paul, in various companies at various places that are going to say, well, wait a minute. You know what? I'm productive. I'm doing this. I'd like to stay where I am. What's going to happen with those? You know, this is a little different than our vaccine conversation. This is just the, you know, don't I have the right to now be able to come forward and say, I want to work where I am, or, you know, can we do a hybrid, whatever it would be? Like, what's going to happen there?
Well, I think employers are really being pushed to the, you know, to decide by the employees, how far are they going to go, where are they going to put their foot down. I think on one side, and, you know, there's a great article in the US in the Wall Street Journal about the mass resignation effect. Everyone in COVID is reevaluating their lives, what they want to do. So maybe if you say to me, absolutely not, Paul, I expect you to be in, you know, 5 days a week, and I'm just not happy. So I say, you know what, I'll look somewhere else. So you may see, I think for employers who want to take a very conservative, you know, we're going right back to work where we were, be prepared for a lot of resignations. I think, you know, in terms of what rights do employees have, it really depends on where they got the right to work from home. I mean, if it only really came from during COVID, I don't think it's going to be enough if you're trying to get it for the employee to say, well, now that's a condition of my employment. I think the employer is going to say, well, I let you. Yeah, I don't think it goes there unless, you know, they were hired during COVID. And then again, it depends on the contract. Maybe it says you have the right to work remotely. And if the employer now then tries to say, oh, you know what, now that we're back, I mean, again, you're going to go back to what does the contract mean? What do the parties agree to at the beginning of the relationship?
So you're going to get employees, and you're going to see this. I'm almost sure, and I think you'd agree with me. Maybe you've already seen it in your practice. You're going to see employees that say, look, I know people are vaccinated. I know things are safer now, etc. I just don't feel safe. I keep hearing about the Delta variant. I keep hearing about it doesn't matter. And I'm producing for you, Madam Employer. So don't tell me I got to come in. And if you tell me I'm fired if I don't come in, I'm going to sue you. Okay. So there's your hypothetical. Is there a lawsuit potentially there? Would that be, you know, at the end of the day? In other words, has the pandemic changed anything to allow that to now be a condition of employment? Potentially.
I think if they're, you know, if they're absent contractual terms, I mean, I don't think if it's just fear, anxiety, or like, I don't feel comfortable. I mean, I think the employer from a business standpoint needs to be wary to say, okay, person may resign. From a legal standpoint, I still think it can be abandonment of employment. I mean, if it's not in your contract, you as an employee don't have the right to just dictate and say, you may want to work from home, and the employer may be foolish to not let you work from home, because, well, if you're a great producing employee, why wouldn't I want to keep you?
But what about these extraordinary times, Paul? I mean, I just say this only because I'm looking at all these cases. I'm looking how judges are trying to apply these principles, because it sounds like you, to me, are arguing the principle, but not in the pandemic context. I don't know. I'm playing, you know, hypothetical judge here, but maybe I'd say to you, if you were in my court, if I was a judge, I'd say, well, Mr. Schwartzman, are we not in a different era right now? Like, I know it's not in who would have ever put that in a contract pre-pandemic?
Yeah. Well, I think employers, I mean, I think it depends where, you know, where we are as we're now today, as we're opening up to stage 3, the case count is so low, right? I think like you have to be cognizant of that for you to say, look, I just don't feel comfortable. It's not enough. I mean, if you're saying, look, I suffer from X and here's my doctor's note, that's a different story. But just to say, like, listen, I'm nervous, Paul, about, you know, going into Brookfield Place and seeing all these guys, you know, in the firm, and I don't want to, you know, I'd rather have the comfort. Sure, that's great, and maybe I'm silly for not, but I don't think you have the right just to say no. You got to come back to work.
There you go, everyone. I just got free legal advice from my partner, who's telling me I better get back into the office. All right. Well, listen, Paul, I appreciate you joining me. I mean, there's so many issues. I mean, we could obviously do an hour on it. And I guess the good news for you is you're going to be pretty busy. So it's,
Yeah, that's right. Yeah, it's
there's,
been fun times.
yeah, no, fun time. And with all of these different conflicting decisions and these different principles as you wait to see it through. But obviously the next big stage for you and everyone working in this area is going to be as it relates to vaccines. I'm sure of it. And, will a court one day in this country say yes, mandatory vaccine, an employer saying it's mandatory that his or her employees get vaccinated is a reasonable request to make? That's going to be very interesting to see that get litigated.
Yeah, I mean, we'll have to. I mean, I think they're going to fall. I think if a government takes a certain step in some principle or requires it for something, right now they've obviously both been hands off. I think you'll see some employers and then courts follow. I think for now, much different than obviously our neighbors to the south. Most employers are basically saying, "Yeah, we'd love you to get vaccinated, but no, just come on back. We don't want to touch it. We're a little nervous of asking," or most are just staying away from it for the time being. But I agree with you. I think it's going to eventually heat up.
All right, Paul. Thanks so much.
Okay, thanks for having me. It was fun.
Okay, Paul Schwartzman, partner at my law firm, Brody Thorning, and we were laughing about it, but Paul joined, as I said, over the last year, and like our place, like so many places of employment across this country where people have been out of the office, and and now we're all coming back, and it's going to be interesting to see exactly how, as Paul and I were talking there, how the issue with vaccinations, the issue with employees, the people I've heard about, re-entry anxiety and all of those things, and what that's going to mean in the context of people and companies getting back on their feet again, hopefully as this pandemic is coming to an end. But again, the pandemic affecting how the law has been looking at things, certainly the longstanding principles in employment law. And in some future episodes, we'll take a look at some of the other areas I talked earlier about family law, for example. And certainly there's been a lot of important decisions in that area as well. All right. Well, that is this edition of Judgment Day. I'm Lorne Honickman. Thank you so much for joining me. I'll see you next time.